on the lower right-hand corner of your screen and let me know what the issue is. But we'll go ahead and get started in about 2 minutes. We'll go ahead and get started in a minute. There's still some people that are logging in, so I want to give everybody the opportunity to be able to hear the presentation in its entirety. Okay, we'll go ahead and get started. First, would like to welcome all of you to this webinar presentation on we received a criminal record, now what? Now basically we'll be going over employers that receive a criminal background check and what they should be doing to comply with federal law and state law and law set out by the EEOC. So we'll go ahead and get started. At the end of the presentation, there will be a question and answer opportunity. If you want to go ahead and email me questions, that is fine too. If you want to go ahead and utilize the chat feature in the lower right-hand corner to ask questions, I'll go ahead and address those at the end of the presentation. For this webinar and all webinars that we've done previously, we always store them and archive them on our website, and it's very simple to get to. You just go to our website under the Resources tab and click on Webinars, and it has our whole library of webinars that we've done in the past. So let's go ahead and get started with this presentation. My name is Cody Farzad, and I am the Vice President of Employers Choice Online. Some of my responsibilities to promote best practice and industry standards with regard to background checks. I like to consider myself an in-house expert on the Fair Credit Reporting Act, and that's the federal law that regulates what employers can and can't do and what background screening companies, can and can't report on background checks. And also need to be aware of state and federal laws that regulate consumer reporting agencies or employment background checks companies. Here's our disclaimer. All the information here shouldn't be construed as legal advice. If you ever have any kind of questions regarding employment law, labor law, please consult with your legal counsel. But we don't give out any legal advice here. What you will be learning today. What records are reportable under the Fair Credit Reporting Act or the FCRA? What type of records aren't reportable under the FCRA? Identifiers associated with criminal records, so basically how are county criminal records held? Furnishers of information, we'll discuss the Equal Employment Opportunities Commission new guidelines, advising employers what to do when receiving a criminal record. Factors employers should look at once they receive a criminal record. We'll discuss the criminal background screening policy. We'll also go over the pre-adverse adverse action process and discuss the ban the box legislation. That's currently a hot topic issue nationwide. And then lastly, we'll finish up with nationwide cursory database searches as a safety net. So again, if you joined us late, please go ahead and utilize the chat feature in the lower right-hand corner with any kind of questions. There will be a question and answer opportunity at the end of the presentation, and you could always email me any kind of questions as well. Okay, so let's go ahead and get started with this webinar. Okay, records that are reportable under the FCRA, the Fair Credit Reporting Act. Any convictions where the subject of the report was either found guilty or pled no contest that were disposed within the last 7 years. And disposed means that they were essentially given a verdict. They were found guilty for driving under the influence. They were sentenced to, 3 years probation and some fines. It would be from the date that that case was disposed going back 7 years. So any reportable records where they were found guilty or pled no contest within the last 7 years is permissible under the FCRA. If they did serve prison time, then the date would start from the release from prison. Probation is not from when they completed probation. If they were given probation in lieu of prison time, it would still be 7 years from the disposition date. However, if they did serve prison time, the date would start from the time they were released from prison. A majority of cases reported are felonies and misdemeanors. Usually that's what employers are concerned with. However, there are some background screening companies or employers that would also like to get infractions or traffic violations. So those are kind of the cases, the standard cases that are reportable. Are felonies and misdemeanors, and then in some courts we do have cases that will include infractions or ordinance violations or moving violations with regards to traffic. Probation and parole violations. If, let's say the case was disposed in 2002, that's obviously outside of the reporting period. However, in 2006, they violated their probation or parole. The reporting period would start at the time that they violated their parole. So let's say they were convicted of Grand Theft Auto in April of 2003, got in trouble again in, let's say, April of 2007, 7 years would start from that 2007 date. There is a salary exception. If the applicant or new hire is going to be making $75,000 or more annually, then you are able to go back 10 years with regards to criminal record. Now keep in mind, there are certain states that have their own laws pertaining to employment background checks. In certain states, the salary exception is reduced. For instance, in Washington, if they are making $25,000 or more annually, you can go back 10 years with regards to the reporting period. Okay, let's discuss now what types of records are not reportable under the FCRA. FCRA Section 605A states that criminal records of arrest that from date of entry antedate the report by more than 7 years. So we essentially don't report arrest records. The reason why we don't report arrest records is a final disposition has not been given. If an employer, let's say, would take adverse action on an arrest record and come to find out the applicant went to court and was found not guilty or the case was thrown out, essentially they were not convicted of that crime. So the FCRA states that any records that antedate the report by more than 7 years are not reportable. Cases that have been either dismissed, not prosecuted, or nolo prosse, they were found not guilty, expunged, or pending are not reportable. And not report cases where there was not a disposition where the person was found guilty or pled no contest. A lot of the times, and that's why we do county-level criminal searches, is we want to get the most up-to-date information. If the case was disposed last year and the person was found guilty, however, they filed for a specific penal code where it was dismissed last week, you would only get that information if you had a researcher go down to that courthouse and pull that record. So you really want to make sure that the criminal records you're receiving are reportable in that they were found either guilty, they pled no contest, and it was disposed within the last 7 years. If it was dismissed, if it wasn't even prosecuted, and you make an employment decision, you could essentially have a claim of unfair hiring practices. Databases utilized where the information is not up to date and fails maximum possible accuracy. The FCRA has identified 2 limitations with instant database searches. Now again, these are criminal database searches that have over 600 million records that give you instant results. The 2 limitations that the FCRA has identified is the first one, not every single county within the U.S. reports their cases to a nationwide database search. So even if it is up to date and it has the most accurate information, if the county where the individual has lived does not report their cases to the database, you're not going to find those records. The second limitation is the majority of the information is not up to date, if you will. It's not in real time. It's not like sending a researcher to that courthouse and searching the court records. A lot of the times it takes, between 2 to 3 months to get records uploaded into these instant databases. I have a request. If everyone out there can mute your mics, if you could just hit mute on your phone so that you could hear me and not essentially hear all of you, would be greatly appreciated. I guess there's some people that are getting feedback from the mics, so I appreciate that. Okay. So again, back to databases. You want to make sure if you are utilizing databases, it's the most accurate, up-to-date information. Because again, if you do have a county that does report their cases, however, the information is not up to date and the person was convicted 2 weeks ago or last week, that's not going to show up in a search. It's also very important to understand that there are diversion programs or probation before judgment sentences that certain counties out there will offer applicants, basically saying that if you complete these certain programs that the court has set out for you, if you complete that within a certain time period successfully, then the case will then become dismissed. So if you have somebody that's actively on a diversion program that is, going to AA classes, parenting classes, drug abuse classes, and once successfully completed, then that essential case is dismissed. So you can't report those cases because, again, there has not been a final disposition on the case. There hasn't been any disposition given. The judge says, okay, if you abide by these terms, we'll go ahead and dismiss the case. However, if they violate any of those terms, at that time that they violated those terms, the case would then be disposed and they were found guilty and therefore okay, identifiers associated with criminal records. These are how felony and misdemeanor records are stored. Primarily, they are stored by a name and date of birth match only. So it's very important that you provide a full name and date of birth when running a background check through your vendor. If it is a common name, making sure that you include a middle name. Other identifiers that may be documented on a criminal case that is not guaranteed would be a physical address, perhaps a driver's license number, or a social security number, or at least 4 digits of the social security number. These identifiers are not guaranteed. However, there are certain cases that may have these secondary identifiers. Back to nationwide database searches. A lot of these database searches are name match only, or a combination of just a last name, first initial, or first name. So you want to be very cautious and review any results you get from a nationwide database searches. With our clients, any hit that we get from a nationwide database search that we feel is reportable, we'll go ahead and research that in the county of record. So once we get that case from, let's say, New York County, New York, and we see that it is reportable, we will report the case and then report the nationwide database hit as well. Again, with database searches, you could have a partial DOB. So if you run a John Anderson nationwide with a date of birth of, let's just say, 1980, you'll get a boatload of hits, and it could potentially, none of them belong to your applicant. A lot of the times, you will not get a disposition or any sentencing information. You may get that this person was arrested at this time for this crime. There's no other information left. And again, you want to make sure you're complying with the FCRA and that you're only reporting cases that have been disposed. At that point, you would need to run that county-level search to see what the sentencing information is. So be very, very careful when you're running these nationwide databases that the hits you get give you the entire picture so that you can make an informed hiring decision. And it is always important to run a Social Security trace, which will reveal, of course, any known aliases and any other addresses. Because, again, criminal records are held by name and date of birth match only. You want to make sure that you're searching any and all names and counties where the individuals have lived. Furnishers of information. So these are individuals who regularly and in the ordinary course of business furnish information to the agency with respect to a consumer. So this is where we pull our information. These are entities that provide public record information so that we could put it into the consumer's report and, of course, give to our clients. So county courthouses. All felony and misdemeanor records are held in each county courthouse nationwide. Go to the courthouse, pull the record either through the clerk or through a public access. That would be considered a furnisher of information. Federal district courts. Part of the service that we offer are federal district crimes as well as civil crimes. That would be at each federal district court. They would be essentially a furnisher of information. Sex offender registries. Because of Megan's Law, each state is required to maintain a list of level 2 and level 3 sex offenders, and they would be essentially a furnisher of information because they are reporting public record information. FBI databases. This has to deal more with fingerprinting. It's a maintained database by the FBI. They would be considered a furnisher of information. Along with other type searches that we do, outside of criminal background checks, schools that report education verifications, employers that provide employment verifications, states that provide driving histories, those would all be considered furnishers of information. FCRA Section 623, reporting information with actual. A person shall not furnish any information relating to a consumer or to any consumer reporting agency if the person knows or has reasonable cause to believe that the information is inaccurate. So if you're pulling criminal records from a vendor that has a database that they know for a fact information in there is outdated, is not reportable, you really, really want to be cautious to see where they're pulling their information from. Our public sources, like I said, maintain these databases, but they're not maintained on a regular basis. Again, if you guys can utilize the lower right-hand portion to ask any questions, would be great. We'll address them at the end. And this entire presentation, both the audio and video of the PowerPoint, will be available on our website. And if any of you would like to get the PowerPoint presentation sooner before we upload it to our website, send me an email, and I'll be more than happy to share this PowerPoint presentation with you. Okay, so let's go ahead and move along. The EEOC, the Equal Employment Opportunities Commission, new guidelines. So on April 25th of this year, the EEOC approved guidance on how employers should be using arrest and conviction records in an employment decision. The guidance was in direct response to national data and claims that found criminal records had a disparate impact based on race and national origin of minorities. So they were seeing an increase in minorities being discriminated against because of their criminal records. And due to an influx of claims, they then issued a new guidance on how employers should be utilizing criminal records. So the guidance mandates employers who use criminal records for employment screening purposes to take additional measures such as the use of validation studies, decision matrices, and individual assessments. So it's really taking a look at that criminal record, looking at the details of it, seeing if it's going to impact your business. How long has it been since the crime occurred? What has the individual done? And have they disclosed that? So they really want employers to specifically look at the specific crime, the specific employee, and do kind of a survey and assessment on business necessity. Here's kind of a sample matrix that I pulled, and it kind of, this is perfect. This is exactly what the EEOC is looking for. This should be adhered to for every single employee that they are running a background check on. So on the upper right, it gives you a kind of a range, 0 to 3 years, 4 to 7 years, and in some cases, 7+ years. Also here on the left, it gives you discrepancies or adverse information related to alcohol and drugs, financial crimes, sexual crimes, DOT requirements. That's if you're regulated by the Department of Transportation. So as you can see, they list essentially crimes that individuals could be convicted of. For the first one, if the person had alcohol consumption or possession of alcohol within the last 3 years, 4 years, or 7 years, they still say proceed on with hiring them. If they had an alcohol sale to a minor or contributing to the delinquency of a minor, if it was within the last 3 years, stop, they would not want to hire them. If it's within the 4 to 7 years, it would be a review process to see again what have they done since then, did they disclose this information. If it was more than 7 years, they would still proceed with employment. So you can kind of see you have a range, you have a matrix on different crimes where the people are convicted of and how long has it been in relation to if they're going to hire them or not. Under financial crimes, credit card fraud, they're specifically saying stop if it's been within the last 7 years. So this is really, really good tool to have in place to make sure that you're receiving a criminal crime, but that you're also doing your part to see if it's going to impact your business. Okay. Now, piggybacking off of that, the new guidance applies to private employers, federal, state, and local businesses. So basically, it applies to everyone. You want to make sure that your background screening policy avoids blanket statements such as anyone with a felony conviction is disqualified from employment. Now, this is kind of very basic, very broad. If you included misdemeanors, that would be even that much more broad and open for discrimination. So you really want to make sure that, again, you're not stating anywhere in a policy or posted in your conference room or wherever you have the applicants complete their application stating that anyone with a felony conviction is automatically going to be disqualified. You want to strongly reinforce job relatedness and business necessity. So again, if all of you could just mute your speakers, I guess we're still getting some feedback, some heavy breathing, if you will. So if you could just mute your speakers, I'd greatly appreciate it. So again, is it related to the job at hand, and is it going to affect your business? Essentially, that's what it comes down to. Okay, factors that employers should closely review once they receive a criminal record. So the EEOC has called them green factors, but essentially there are 3 factors that an employer must look at a criminal record once they're going to make an employment decision. Is the nature and gravity of the offense or conduct, the time that has elapsed since the offense or conduct or completion of sentence, and the nature of the job held or sought. Sorry, there was a typo there. So these are the 3 things that employers must look at once they get a criminal record. They also want to make sure, was probation and all sentencing requirements completed? Did they complete what the court asked them to do? Did they abide by all probation or parole standards? Did the applicant disclose the record prior to the background check? A lot of times, employers, if they are allowed to inquire about the applicant's criminal history before a background check's done, gives them the opportunity to disclose if they've ever been convicted of a criminal background. And I'll be honest with you, probably 100% of the time, if we report even a minor crime to an employer where the applicant didn't disclose it, no matter what the details of the crime are, they don't want to hire the person just for the simple fact that they're not honest. So I put integrity down here. Essentially, integrity is doing the right thing when no one is looking. If someone discloses a criminal record, it doesn't come as a surprise to that HR person or that hiring manager. They would obviously think that this person has some character and a moral compass and would kind of maybe take into account that and still would want to hire them. So it's real important, if you are allowed to ask about previous criminal activity on an application, go ahead and do that and just see if your applicant is honest. No matter what the crime is, you don't want to hire somebody that is going to be dishonest. Criminal background screening policy. Just like any kind of process or procedures that a company does, it's very important to have a policy in place stating why the company is doing what they're doing. We did do a lengthy, specific webinar pertaining to background screening policies in the past. It is on our website, so I encourage all of you, if you have not already listened to that, take a listen to it, especially if you don't have a policy in place regarding background screening. The main advantage of having a background screening policy is it eliminates claims of discriminatory treatment. So by stating who's subject to backgrounds, what positions are our background checks going to be done on, specifically what searches are going to be associated with those positions, really spells out specifically why the company is doing backgrounds and can easily decrease claims of discriminatory treatment. If a claim is brought against an employer for unfair hiring practices, the EEOC will ask for a criminal screening policy in place. You really want to make sure that you had a policy in place, that your decision was in complete compliance and agreement with your policy. Set parameters, matrix for disqualification of employment. That goes back to the chart that I had showed you. You really want to make sure it's not a gray area. It's very black and white as to specific crimes where the company is not going to hire the person, where they would take a look at the crime, or you know what, we could go ahead and look over that and continue with the hiring process. There are seven crucial sections of a background screening policy. These are 7 sections that you should have in your background screening policy. So the first one is the purpose of the policy. Why is the company doing the employment background check? Scope of the policy. Who's going to be subjected to the background? The responsible organization. Which department is going to be responsible for facilitating and managing the background screening process? Sensitive positions. If there are sensitive positions within your company that require additional searches outside of the scope, then you want to list those. The hiring manager's responsibility. What is the hiring manager's responsibility with regards to receiving background checks? Are they going to be the ones reviewing it and making the employment decision? That's what employers should know. A retention of records. How long will records, compliance forms, disclosure forms, reports be on file for? And of course, legal compliance. If you are complying with any federal or state law that requires you to do background checks, we're specifically stating that. Okay, so you have received a criminal record. You did your due diligence to make sure it does belong to the person. You took the 3 factors into account, and you still do not want to hire the person based on this criminal record. Anytime you're going to be taking adverse action based on a background check, you must do the pre-adverse action process to comply with the FCRA. And that essentially is giving the applicant the opportunity to view the report and dispute any of the information. So if an employer decides to take adverse action in whole or in part on information contained in the consumer report, the employer must take the following action. Pre-adverse action. Provide the applicant with a copy of their consumer report, provide the applicant with a copy of their consumer rights under the FCRA, and provide them with a copy of their background check. That is given to the employee so they are able to know, okay, a background check was done by employer's choice, derogatory or adverse information was reported, and specifically this was the information that was reported. They have the opportunity to contact the background screening vendor to discuss the information. If the information is inaccurate or not true, then of course they want to contact us to see if a reinvestigation must be done. I'll be honest with you, in my 5 years of doing this, probably 3 to 4% of applicants will contact the background screening company to discuss the information. Reason being is all the information we report is public record information. Again, we use licensed researchers. We pull a credit report straight from the credit bureau. We don't manipulate any of the information. We don't investigate any of the information. However, we'll be more than happy to talk about it with the applicant. But once 5 days have passed, and obviously the information is true and correct, there's no reinvestigation that needs to be done, the employer must do the adverse action. Again, sending a copy of the report, a copy of the FCRA Summary of Rights, and again, a copy of their background. At that point, the employee-employer relationship is done. Nothing else needs to be done. They're no longer considered for employment. At any time, if an applicant contacts us to discuss the information, we'll always let our client know. But again, it's a very, very small percentage of the time that they do call us. Your background screening provider may offer this service at a cost for you. We do offer our clients to take this process out of their hands. We will draft the pre-adverse action letter and send it out. And then, of course, after those 5 business days, we'll then send the adverse action letter. So check with your vendor if this is a service that they do provide, but please make sure you are doing this if you're going to be making an employment decision based on a background check. There have been a lot of companies out there recently that have had hefty fines levied against them for violating this part of the FCRA. Ban the box. This is a real hot button issue right now. Basically, ban the box is, should employers be able to ask a job applicant about prior criminal activity, essentially on a job application. So for all of us that have completed job applications or even created job applications where you put on there something to the effect of, have you ever been convicted of a felony or misdemeanor crime? There are quite a few states and cities that have adopted a law to ban that box. So basically, Connecticut, Hawaii, Massachusetts, Minnesota, and New Mexico, as well as the cities of Atlanta, Baltimore, Chicago, and Philadelphia, make it illegal for an employer to ask about any previous criminal activity before a background check is going to be done on them. I kind of see other cities and states falling in line. I don't necessarily agree with it. I have a different opinion about it, but keep in mind, if you are in those states or in those cities, check with your employment law attorney or your legal counsel to see if your application does comply with this law. So if you are permitted to inquire about previous criminal activity, how do you pose the question on an application? So if you are allowed to ask about prior criminal activity, how can you put that on an application where there's no questions, it's not lost in interpretation? We like to say, have you ever been convicted of a felony or misdemeanor crime? You don't really want to put a time period, but you just want to know, have they ever been convicted of a felony or misdemeanor crime? Convicted. I've seen applications poorly written as far as, have you ever committed a crime? Have you ever came in contact with the police? You really want to make it as specific and as not lost in interpretation as you can. But please make sure that in your city or state you are allowed to ask that question about previous criminal activity. Nationwide database searches as a safety net. This goes back to the beginning of the presentation when we were talking about databases and are they up to the minute information? Is the information updated in real time? A nationwide database is really, really good to do in conjunction with county-level criminal searches. Now, when we do a Social Security trace and we identify where the individuals have lived, we'll go ahead and do those criminal background checks. However, if the individual works in a different county or has traveled outside of where they've lived and may have committed crime, those crimes aren't going to come up in county criminal search based on where they've lived. So it's really, really good to do a nationwide database search as a cursory search to see if there's any other records out there associated with this person that may have not come up in the county level search. Like I mentioned, there's over 600 million records nationwide in a criminal database search. It is only effective if it's combined with county level searches. It should be good and it would be utilized as a cursory tool to see again if there's anything else out there. Remember that Social Security trace will only reveal county of residence, not where they've worked or where they've visited, anything like that. And like I mentioned earlier, any and all hits from a database search should be researched in the county of record that you could see if they were convicted of it, what was the sentencing information. You don't just want to go ahead and make a rash employment decision on a database hit that doesn't reveal the disposition. What if the person was found not guilty or, the case was later dismissed? So any hits that we get on a nationwide database search, researched in the county where that record is held. Hopefully that all makes sense to all of you. And that's it. We have a Q&A period now. Let's go ahead and look at the chat box to see if there's any questions that I can address, or if you guys want to go ahead and speak into the phone, I'll go ahead and take questions now. Somebody asked about military records. Employers or background screening companies can offer military verification. The turnaround time for that is almost up to 4 or 5 months. Because companies have to go through the National Archives and get a DD-214 from the applicant. Essentially, once someone is discharged from the military, they receive a DD-214 form. And that form must be given to the background screening provider so that they can go to the National Archive to verify that information. But I'll be honest with you, the turnaround time is, like I said, anywhere from 3 to 5 months. They're so backlogged, they're so understaffed in getting these done. But yes, background screening companies can do military verifications, it will just take some time. Other question, can you offer any advice on what to do if a background check reveals an active warrant? Well, obviously a disposition hasn't been given on an active warrant. This information is permissible and it is reported, is allowed on a background check. A lot of the times the individuals don't know that an active warrant has been issued on them. It could be as simple as they had a speeding ticket, they didn't report to court, they had a failure to appear, and now that becomes an active warrant. So what we like to do is let our clients know outside of a background check that, hey, this person has an active warrant. It may be a good idea to have a conversation with them, find out if they knew about it, and if they did, what do they plan on doing to remedy the situation. If they have a court date, and that would be a good idea. But with active warrants, you really, really want to side on caution in that, again, there has not, a disposition has not been given. It could be as simple as going to court, paying a fee, and the warrant being taken care of. So if you have a good relationship with your vendor, they could let you know that, hey, there is an active warrant that you may want to discuss with the applicant, that you may want to go. Like I mentioned earlier, all of this entire presentation will be uploaded to our website in about a week. If you guys would like a copy of the PowerPoint presentation quicker, you can email. That won't be a problem at all. If you have any questions that come up later on, don't hesitate to email me those questions and I'll get back to you. So if anybody doesn't have any other questions, I do appreciate all of you taking the time out to sit in on this webinar. Again, we kind of like to do these quarterly. We appreciate any feedback. If any of you are passionate about a certain topic relating to background checks or would like to hear more about a specific search or law, please don't tell me to gear these presentations towards what our clients and prospects and consumers, whoever would like to view that. So I do appreciate all of you taking the time out to listen to the webinar. Please look out for our monthly newsletter, Workplace Background Source. And again, if there are any questions that you can't think of now, but they do come up later, reach out to me. I'll be more than happy to get an answer to you. I do appreciate all of you attending, and take care, and you guys have a great and wonderful rest of your week. And again, thank you.